mention in Interdigital Technology Corporation and others, and Lenovo Group Ltd and others.
Mr. Speck. My Lord, this case concerns an invention which provides a new procedure to be used in enhanced uplink in UMTS. Its context is the medium access control or MAC layer, and specifically it concerns MAC multiplexing and TFC selection in enhanced uplink. TFC is short for transport format combination, and obviously nowadays, because it's enhanced, it's called eTFC, E being short for enhanced. Now, first thing I should say is my learned friend objects to the invention being described by me as a procedure in his objections, right? Saying that that's a new departure on our part. That objection is rather surprising, given that the title of the patent in suit, which is at tab 2, the supplementary bundle, is MAC multiplexing and TFC selection procedure for enhanced uplink. It's all the more surprising because, I'll come to it shortly, his own expert, who notably said not a word about the point that we're concerned with in his reports, clearly described the claimed invention in terms which is describing a procedure, identifying the steps required by the claims, which are consistent with my case, but not notably my friend's. So there's nothing in that complaint. The appeal that I seek my Lord's permission to bring is an appeal against the decision that my client's patent was anticipated by the prior art scheme, not on the primary case advanced by Lenovo for its expert evidence. That case was comprehensively rejected by the judge, held the invention both novel and involved an inventive step. The case we're concerned with was a new case advanced for the first time in cross-examination, based upon the same prior art system but not foreshadowed in the evidence. Ultimately, it's a point of construction of the patent, and it's one where my submission to my Lord is that there's a real prospect of success. Indeed, I'd say it's more than that, although that's the hurdle I must overcome today. And I do also say it's a point of some significance more broadly, because all patents are obviously ultimately construed in themselves individually, but this is a patent of a kind that's not uncommon in the telecommunications field, where a new procedure, a new set of rules or criteria are proposed and sought to be claimed. How one applies the rules or criteria may not matter for the invention, but actually applying them does matter. And if the judgment below is allowed to stand, that may have significant consequences for the protectability of such inventions, because their utility often are in the application of a new set of rules or criteria that enable an advantage to be achieved across a population of mobiles, as in this case, as I'll explain. Right. And to be able to point to chance circumstances which may arise for individual phones, where applying different criteria or rules may on occasion lead to the same outcome for an individual phone, is not to point to anything that's applying the invention. In fact, I was thinking this morning, this point may be somewhat similar to the point advanced on an appeal to my Lord in the Optis and Apple case recently, where pointing to the possibility of the same outcome as the patented procedure was said to invalidate the claim on a particular construction. My Lord may not remember because the construction then didn't arise, so you didn't decide the point, you just said you'd leave it for another case. But it may be that kind of point. Okay. And the nub of the point I can illustrate before I get into the detail by considering the way I try to illustrate the thing in the application for permission. Consider something much more homely example. Say there was a patent claim that called for a procedure to select a person based on his or her height. Right. Say the tallest or perhaps the third tallest, it doesn't matter. And what we're looking at, the kind of point we've got here is the defendant responding by suggesting that the court consider a particular population of people and a procedure where you select on the basis of weight using scales, and you happen to get the same person sometimes. Right. What the point is that if you're applying different rules, sometimes the outcome will be the same, but it doesn't mean that, for instance, weighing scales are means to select the tallest person. Right. It's that kind of point that we're looking at. And it's obviously the means that we're talking about in this case are going to be, in a practical way, programmed logic. But the programmed logic is still applying measuring the weight or measuring the height. It's still doing what the claim requires in my submission, or should do. And if an argument of the kind that was allowed to succeed here stands, it would apply likely to just about any other method using completely different means on any basis, may do it by random, for instance, may end up with selecting the same thing and getting the same outcome on occasion. And that's, in essence, what my friend's argument is, and one accepted by the judge. And the reason it was said to be necessary is a so-called squeeze on infringement. And the judge and my friend says we're driven to that conclusion because of this so-called squeeze. And I'll come to the detail of what it technically is in due course. But it's, in effect, saying because you don't have to do it all of the time, you don't have to use the tape measure all of the time, you still have the means to select the tallest person when you do something completely different and you don't have a tape measure at all. And the point is, my lord, that it's a very different kettle of fish moving to something where you don't have the same criteria, you don't have the same means at all, to simply saying that the means that you do have to have, on occasion you don't have to apply because a different rule applies. Your lordship's looking puzzled at me.
No, I'm not puzzled. Well, I am puzzled, but I mean, look puzzled or not.
But that's the nature. That's the nature of the squeeze argument.
Is it though? I mean, the trouble with analogies is,
of course,
I know that, but your claim doesn't have a tape measure. Your claim is defined by the outcome, not by the fact that you've used a tape measure.
Well, it's means to limit. It's means to limit.
Yes, means to limit. Means to find the tallest person and it's not means to find the tallest person in every circumstance, because that's the construction point. The construction point is that the claim isn't avoided by a method or a system, procedure, if you will, which won't find the tallest person in certain circumstances.
Well,
so it only that's right, isn't it?
No.
No. Okay.
Means to identify the tallest person must be applying the criteria of identifying the tallest person, not selecting at random and occasionally the tallest.
Well, random. I'm not very interested in random because I don't buy random.
On weight, then. On weight.
Well, hang on. Well, the claim is a claim for identifying the tallest person. Any method which will identify the tallest person. And what's put against you is that there are certain circumstances in which, when you follow the prior art, in those circumstances, deterministically, the result will be you'll identify the tallest person. The fact you do it by weight isn't excluded by your claim. You still identify the tallest person in certain circumstances. And whenever those circumstances arise, it's not random, whenever they arise, that's what happens.
Sure.
And it's the tallest person.
That's not what the claim means in my submission.
Okay.
It's not what anybody thought it meant until the cross-examination.
Well,
and that is the point of construction.
Well, I don't understand the construction.
Right. Well, let me show you very quickly. I was going to come to it soon, but let me show you what their side said the claim required.
Okay. I've got to tell you, honestly, I'm not sure that'll help you, Major, but Mr. Speck, but
well,
but if that's what you want to do,
well,
please do.
What the claim requires is for you to identify. Right, I'll show you. I can't really put it any better than 8.38 in the supplemental bundle, I think, which is their expert evidence. And I was going to come to this shortly when I show you how the point was developed at trial. So this is their.
So where am I going?
I'm in tab 7 of the supplemental bundle. And if you go to page 65 internally.
Anybody know what that is in the PDF?
148 perhaps, if you've got the bundle numbers.
And it's para 8.33, did you say?
8.38. So it sounds like it's probably slightly
pretty close. Yeah, I'm nearly there.
But you see here, this is their expert explaining. There's a little bit of narrative about the invention and the claim in 8.37, and he summarises what the claim involves. Identify a size of MACD flow allowed by the serving and non-scheduled grants available for transmission. Then choose the largest ETFC size that's smaller than the size. Then limit the MACD flow data to fit in this ETFC size. That's what they said in their evidence the claim involved. Now, they're not saying that now. They're saying do anything which ends up with a MACD flow data that is of a size that fits.
Right.
That's their construction now. It must be. They do not suggest that you have to identify, you have to do step 1, step 2, or use that value and apply it as a limit. This is their evidence, though. This is the construction that they identified. There were other arguments about whether it included headers and so forth. But in terms of the basic of what you're doing, and I hope my Lord sees the difference. There is a difference. Right.
You asked me, so the answer is no, I don't.
No, well, that's really helpful to know because that is a problem. If your Lordship doesn't see the difference between using the criteria that's set out in the claim to select something or to do something, or just doing something else which gets you to the same result, that's the nub of what the dispute is.
Right. And I'm looking at the claim. I'm not really interested in what somebody said it might mean.
Okay.
I mean, I'm interested in what the judge said it might mean, but I'm not interested in what your opponent said it might mean. To be
Well,
accurate.
you're interested in what they say today, but I understand the point you're making. You're looking at claim 1.
Yep.
Means for limiting.
Yep.
It's rather wordy. I'm looking at around about line 27 in the patent. Means for limiting. This is into 1F. The MAC-D flow data multiplexed. 2, and then there's a wordy way of identifying a particular size, which is the largest ETF size that's smaller than the sum of the grants, basically.
Yeah.
So the dispute between us is: do you hit that claim by doing absolutely anything and ending up with something which is smaller, or do you have to identify the ETFC size and use that as a limit? Impose that on the multiplexing as a limit. And that's the difference between us.
Where does it say in claim 1 that you have to use something as a limit? Claim 1 is ultimately a product claim.
It is a product claim, yes.
And it says means for limiting the MACD flow data multiplexed into a
Yes.
MAC EPDU.
And it identifies the limit. And my submission to my Lord is that the proper construction, at least arguably, the proper construction of that is that you have to identify that, go through the steps of identifying the largest ETFC, have that size and use it as a limit. Means for limiting the multiplex data to that size means applying that number as the limit.
Right. I don't understand what you mean. My understanding, and you tell me if I got this wrong, is that what's being put against you is a circumstance in which the MACD flow data, in the case that's put, and I'm looking at the judgment, that diagram from Mr. Town in para 305A, as MACD flow data, which is, in that context, smaller than the relevant ETFC size.
It's also smaller than the next one up. It's smaller than all sorts of things.
Right.
But it didn't get there by applying the limit that the claim is talking about. Shall I tell you what the squeeze is so that you can see that it's nothing to do with this point at least?
Okay.
I was going to explain the invention to my Lord, but I think I'm going to skip over that bit given...
I think I kind of understand what the invention is. I may be wrong, but...
Well, very briefly, the invention enables a lower proportion of what's sent across the cell to be padded.
Yeah.
Because you end up making the gap that's between what you've multiplexed and where your ETFC is all smaller than the multiplexing block. Yeah. You might be restricting an individual phone what it sends in the
across the network as a whole.
But overall, and so that's why it's a good idea, and that's why it's counterintuitive.
Okay.
Yeah. So that's the invention. The squeeze, the judge dealt with in the judgment at a section beginning, basically para 147 started with construction. So I'm in tab 5 of the core bundle.
Yep.
And there were several construction points that don't matter to this. The one that matters for the so-called squeeze is under heading means for at para 181. And this is dealt with quite quickly. He only deals with it under means for, and it's not perhaps the most apposite part of the claim to squeeze this construction point into, because it's said to apply to the method as well that doesn't have the language. But the argument in a nutshell is this: because in the actual infringement, in some TTIs it does something different, there's no infringement. That's the argument.
Yeah.
Because it does something different on another occasion. Something different. And you can see the argument set out in this section. My argument was, provided the apparatus has the requisite means, it infringes even if they're employed only some of the time. So it has to have what we say are the means, but it doesn't have to do it every TTI. And it's apparent, as you can see here, that our argument's not the possibility of not having the requisite means at all, and occasionally achieving the outcome that could also be achieved. It's just about whether you have to do it every TTI.
Yeah, I understand.
So it's got nothing to do with, although the judge said that it had consequences when he decided this point on construction in my favour, it's got absolutely nothing to do with the squeeze in my submission.
Okay.
It's simply that on occasion, and it's when the data doesn't have any scheduled data, you do something else. But you do have the program logic, which does apply the patented criteria most of the time.
Right.
And it is there. You don't escape infringement.
The question is all about what is the definition of this patented logic, and that's what this is all about.
Sure,
and
I
I
understand
understand
that.
the point the judge is making. What the judge is holding is that the definition of that logic means that the logic is logic within the claim, even if in some TTIs the result isn't the result claimed in the claim. That's what the judge is saying. In some TTIs you don't get this functionally defined result, and in other TTIs you do. And that's why, and if those are the facts, as you say they are, then the claim is satisfied, because in some TTIs...
He's not quite putting it like that at this point, my lord. He's saying if you've got the means and they're not employed in some TTIs, you still have the means.
Okay.
And that's a different point. That is, it's really crucial that your lordship understands that there's a different... You've got the means that applies the limit of the claim, but you don't use them every TTI. And that's what he's identifying. Look, the argument arises, he says in 182, and basically he says our argument is you have the means, but it infringes even if you don't employ them all the time. Then he identifies in 182, it arises because in the standard, the integer 1f means are employed when scheduled data is to be transmitted, but not for transmission of non-scheduled alone, since there'll be occasions where there's only non-scheduled data sent. Lenovo will argue there's no infringement. So he's actually looking at the argument on my basis. The means are there, but you don't use them all of the time.
When you say you don't use them all the time, I mean, it depends what level of generality you're talking about, as I understand it. There will be a there will be a selection of the right transport format. Sure. Every time.
But what
and
happens?
No, that's right, isn't it? I mean, it might not be right, but I think it's right.
You have a transport selection every time.
Yeah, and in the standard, as I understand the point that's being made there, sometimes that selection will comply with your claim, and sometimes it won't.
Well, it's more than that, my lord. It's actually saying the means are there because the program logic is branched to, it's active.
Right.
Some of the time.
Because there are circumstances in which the program says, I don't want to go down that path, and there are other circumstances in which the program says it does.
But there are program logic that does do it.
Yes, I understand.
Right.
But the point that's put against you is that if you follow the prior art, then you have program logic which, in the circumstances that are defined, which I think is something to do with non-scheduled, it's all non-scheduled data grants or something like that. I'm saying that as if I know what that means, but I'll say that. That in those circumstances, the point that's put against you is that the functionally defined result is what happens, and therefore the means, because it's only a means for achieving a result, is satisfied.
It's not only a means for achieving a result in that sense. It's a means for limiting. So it's a means for applying a limit.
Well, it's a okay. If it's not a means for achieving a result, you need to tell me why it's not. I don't understand why. I mean, means for, and then everything that follows. At least until today, I've always thought meant means for achieving a result.
Sure. It depends what you mean
by
that. It really does, Michael, because it means for achieving a result. It certainly doesn't matter. It certainly doesn't matter what the program logic is. It certainly doesn't matter if in a thought experiment you imagine a phone with little people in that do it manually. All of that I absolutely accept. But they are applying the criteria that is the subject of the claim. They are limiting it using or by identifying the ETFC size that's the relevant one and then using it as a limit. They are not just doing it by accident, by applying different rules. And that's the nub of the construction debate. Are you selecting the heaviest person by just using a tape measure and picking the tallest or the fifth tallest or whatever? Or are you selecting the heaviest person by using means which does measure weight and then comparing weight? Are you applying the criteria that the means are saying that you're supposed to be applying? And it's got nothing to do with the squeeze, the so-called squeeze about purporting to do it some of the time and not other occasions. Because on the occasions that you go down the branch in the program where the program logic is being used, you are applying the criteria. It is there in the phone. It's just on some occasions it isn't operative. And that's what this discussion on the squeeze is all about. On some occasions it's not operative. That's all. It doesn't mean that it doesn't have the program logic that applies the criteria that is in the claim. And if you just think about it, my lord, just more broadly, many of these claims are claims like this, where they identify criteria, rules that have to be applied, and basically claims that say means for applying this rule. If you're to say the rule is simply identifying an outcome and you can get there other ways, they're all invalid if you get there other ways, that is something that's going to have an effect more broadly on patterns like this.
But isn't it just a problem of drafting? If your claim had said identifying X, identifying Y, and then means for doing this, then this accidental anticipation wouldn't do it. But your claim doesn't say that. It simply says means for, and then all the words after means for, at least to the incautious, conventionally minded patent person, are a functional definition. They're only a definition of the result, nothing else. They're not about how you get there, they're about the result. That's what means for usually means. And you're saying that in this case it means something different.
Well, in the method claim, limiting, and then you identify the limit that you put on it, said to be anticipated by something that doesn't do that.
Does your method claim has the same language in it?
It has the same. Well, it's on the means for though. What I say, it has limiting the data multiplex to, and then it identifies. Let's have a look at the language. It's tab 2, I think, of the. And the method claim is.
Where are we?
Sorry, it's the next page. We were looking at tab 2 at column 14.
Ah, you were, I wasn't. But
Oh,
I was
okay.
looking at the claim in your skeleton, but it's all right.
Yeah.
I declare. Where's the? So hang on. What, you want the patent?
I was looking at the patent.
Yeah.
I mean, it does make it a bit difficult because it is wordy things, but if you look at column 15,
Hang on.
we're in claim 5, which is the equivalent, and the key claim is limiting. You see that?
So hang on. I'm on claim 5.
Yeah. So you
Method
want,
for multiplexing and so on.
and what you want is the column 15, where you see the indented bit, and then around about line 17,
I see,
limiting.
I see.
So it's limiting MAC D-flow data multiplexed into the enhanced PDU to the largest ETF size that's smaller than the MAC D-flow data allowed by the grant. So you're limiting it to a size which is identified by basically the one smaller ETF size.
Okay.
Now, the argument here is that any limit however much smaller than that, however it arises, is limiting it to that. You don't apply that rule, you don't identify the ETFC size, you don't look for the you don't identify the sum of the grants, you don't identify the next smallest ETFC size and use that size as the limit. The argument is, if I limit it to anything, if I have a rule that says I'm limiting it to 10 bytes, if it is smaller than that, that's within that claim. That's the argument. And I say that is not the proper construction of this claim. The proper construction of this claim is to use the information there, identifying the ETFC size, and using that as a limit. It's not right, in my submission. And it's perhaps notable that the judge didn't actually consider the method claims separately anyway, but I say that the same substance is on the means for as well. You wouldn't understand this as any method that ended up with a PDU that happened to be below that limit, however you got there, had been made by a method which limited the data to that size. It simply didn't.
Okay.
It simply didn't do it. And and your lordship says and I understand why you say you don't care what the expert said to start with, but it is notable that neither of the experts read this claim as meaning that at all. The technical people, of course, construction is not for them, but they have to say how they understand it to give their evidence. And I've just shown you what their expert said was involved.
Right.
And that involved identifying firstly the sum of the grants, then identifying the correct ETFC, and then using that as a limit. Had those 3 steps set out.
Right.
And that is, in my submission, the proper construction, technically, what you'd understand, something that is introducing a new procedure. Invention, the title of it is a new procedure, tells you what the rules are, what the advantage is, and then it sets out, it doesn't matter how you apply that rule, and that's, so to use the means for, it doesn't matter what the program logic is, and as I said to my lord, rather facetiously, it doesn't matter if you have little men doing it.
No, I understand.
But that's a different point to saying you can do it by just not having those rules at all.
Oh, I get it. Oh, I see what, I mean, Mr. Speck, I can see exactly the point you're making. When you're looking at Claim 5, I'm bound to say I'm not convinced on Claim 1, but I can see that Claim 5 is written.
Well, Claim 5's enough for me.
No, I get it.
Claim 5's enough for me.
And they weren't taken separately, were they? They were treated as being the same.
Sure,
In
but
the judgment.
But
and in the argument.
well, he never separately dealt with Claim 5, but the decision that he made was that I lost on it all.
Yeah, I understand.
And
I'm right, am I, that nobody suggested, and it would have been you suggesting it, that even if that was right for Claim 1, it wasn't right for Claim 5.
nobody took a separate point on that, no. But the point that I did advance is good for Claim 5. I say it's good for Claim 1 as well. Your Lordship, I think, is saying that maybe I'm better on...
Well, I don't know.
But can I touch briefly on how the point arose at trial? Because that does help my Lord as well, I think. And as I think I've already foreshadowed, you wouldn't have detected it at all in the positions and the evidence.
I got that.
Yeah. And I've shown you already Mr. Irvine's, Dr. Irvine's main report. And he identified those 3 steps. But what happened was a diagram was knocked up and put in the cross-examination bundle. Before I show you that, can I show you what it came from, which is actually in the supplemental bundle.
Sincerely, Mr. Speck, why does this matter?
Well,
I have the point that you submit that this was one of these last-minute things that came out in cross-examination. I understand that, and you say it wasn't foreshadowed. One answer to that is, well, if it really had taken you by surprise, then you should have raised that at the time. And if it meant that, for example, you needed time to think about whether you even needed to amend the claim so that it put in fresh limitations.
That's not my point.
You could have done that.
That's not my point.
Okay.
It's not my point. I was just going to show you that it's not how the experts understood the claim. It was thought up at the last minute and dealt with incredibly briefly
I understand.
in submissions at the end, and in a way where what my friend was really trying to do was to say it had something to do with this squeeze point on the temporal thing as to whether you have to do it each TTI. And I think the way your lordship's putting it to me is that it's not actually got anything to do with that. It's just to do with the words of the claim, or at least that's the way you see it. So, can we just look at the judgment then, where he deals with it?
Yeah.
So we're in the judgment, and the diagram is shown at the top of 78.
Yep.
And I hope my lord understands that what this is actually doing is identifying a particular scenario where you can get this effect by putting that ETFC very close to, but below the red line. That's how you get it. And what was established in the cross-examination is that this is what the size of the Mac PDU that was constructed would be in those circumstances. And you can see the key question at the bottom. In this scenario, the UE would limit the amount of MacFlow data to be within the largest ETFC size. You see that right at the bottom of the page?
Yeah.
And the witness accepted that and said it because of where the sizes
So
were.
the UE is calculating the number of bits allowed by the relevant grants in that context. These are all non-scheduled grants.
No, it's nothing to do with non-scheduled, my lord.
Oh, right. I thought it was. I thought you said that in your skeleton.
No, that's when the infringement does it.
Okay.
This is the prior art.
Yes.
So this is not a point on non-scheduled or scheduled. This is
Okay.
This is quite important. We should understand that this is not the schedule. This is nothing to do with the way the point arose as a non-infringement point on the infringement. This is simply that there are some grants. They can include anything.
All right.
But because the sum of the grants is just above where there's an ETFC, and because you can only multiplex in blocks, using the old rules of just using the individual grants and adding in bits and bobs until you're up to each grant, can still leave you slightly below. And if that gap includes an ETFC, you go for one which is in fact smaller, without having any multiplexing limit at all. That's the way in which my friend constructed that drawing, which was a modification of one of the diagrams that his own expert put in. But it's not applying any multiplexing limit, overarching multiplexing limit of the claim. It's simply applying the grants individually to each category to which they apply.
See?
So that's how you get there. Okay. But it's all kind of hidden in the words "to be within," because it's limited to be within anything that is bigger than it. What is not suggested is that you ever use that ETFC as a multiplexing limit.
And the reason you say that is because I'm just looking at the diagram.
Yeah, it doesn't come in tail right below. Let me show you what the diagram does.
Just a minute. So I'm looking at the diagram. So you start off, you calculate the number of bits allowed by the grants, and there you get it, and there you get the red line.
You don't actually do that.
Okay.
Actually, if you go back, 315. No, sorry, not 315. 316 explains that point. It was a shorthand because they are used as an individual allocation for each category.
Right.
Mr. Townend made it clear that when you're doing that first bit, you're not actually using them as an overall sum, as an overall limit. They're sort of used one by one collectively to create an overall amount that you can put in.
And this is the line 2.
Yeah.
You create this overall amount, taking into account the grants.
Well, your lordship has to be quite careful about the text that's down the side of that, because that was taken from Mr. Townend's first report, and they were purporting to show something
Yes.
It was close to it. And he was saying you don't actually calculate a number allowed by the grants. You're just using each grant individually. So in a way, Category 1 has a limit on what you can put in because it's its grant. Category 2 has a limit, and he's just explaining that. But that's not the point that Mr. Abrahams is getting at.
Right.
Mr. Abrahams is getting at that you multiplex using those rules, and you see that in the second line. So you multiplex simply using the grants.
Okay, you multiplex using the grants. So notionally, at any rate, if you were sort of sitting watching from the top, you can see that the phone has dreamt up that rectangle at line 2.
Sure, and it stopped multiplexing for each of these categories when each one got to its limit, or such that an extra block would have taken it over.
So the multiplexing stops at the end of line 2, as it were.
Yeah, and you haven't even looked at the ETFCs by the end of the multiplexing, and that's why you're not doing what's in the patent, because you have to identify an ETFC size and use it as a limit in my submission. So all he's showing is that you end up with data that's of a size which is in fact smaller, and then you add the padding and it goes out in that ETFC. But it is in fact smaller than ETFC 5. It's smaller than every number that's above that as well. That ETFC size has not been used as a limit. So that's what they say leads to an anticipation of both Claim 1 and Claim 5.
Right.
We say, no, you actually do have to use that size.
And you say it's not a limit because it was never going to be bigger than that.
Yeah, just different rules. You haven't limited it to that size. What you've done is apply some rules on grants individually, which happens to leave you with something which is smaller.
Yeah. So the ETFC size has not acted as a limit.
Yeah, you don't even look at it, and you can see it in the diagram, so you don't even look. It doesn't even come in the diagram until you finish the multiplexing. It simply comes in at the stage where you identify the ETFC that's going to be used, so you know how much padding to go on. So, my lord, that's the difference between us. And in my submission, it's a well-arguable point of construction on both of the method and the apparatus claims. And it is, actually my submission is that the judge's construction would be surprising to technical people. But I don't have to go that far today, I just have to show you that I've got a reasonable prospect of success. There may be further points on the fact that the real fight on the prior art wasn't actually about the document, but how the CGK system was understood to operate, which means that I may have a further point on this is actually being construed to cover something that everyone was old as well.
Right.
Which your lordship knows it's not determinative, but maybe a factor. Because what's being basically said is that you're just applying the ordinary grant rules that were known, gets you within the claim. Nobody would understand that this patent was directed to doing that.
Right. Well, that's that may be answered by the famous words of Mr. Justice Laddie, but the patent system is not a branch of the social services, and if you've drafted your claim in a particular way,
it's not.
No doubt you didn't intend to cover the prior art. No doubt.
No, but it's a factor when the skilled person would have known about the thing. It's the Virgin Aircraft.
In terms of, I get it. In terms of interpreting words that are capable of being interpreted in different ways, then
sure.
it does. In some cases, it is a driver of interpretation.
It's a factor. But in my submission, particularly, I think your lordship is more attracted by the method claim argument. But the idea that doing this is limiting it to that size when you stopped before you've even looked for the size. We say we've got a well-arguable attack on the judgment on that. Because that's the effect of what he's done. Can I just check to see whether there's anything else? Unless your lordship's got any further questions.
No, I want to hear from Mr. Abrahams, if I may. Thank you, Mr. Speck. Mr. Abrahams.
There are various points I'm going to make. If there's anything particular that your lordship wants me to go straight to, then obviously I'm keen for any such indication.
Well, I'll tell you. I mean, at the moment, I'm puzzled why there isn't at least a real prospect of success of this argument arising in relation to the method claim. Yes, the method claim.
Yeah, so that's claim
It
5.
does look as though, yes, for claim 5, it does look as though, at least from the way Mr. Speck has made his argument, that there is a sensible argument to say that this method is not a method which limits, is involving limiting the multiplex data. And that's his point. And he said, and I can understand why in a product claim which is defined by function, that might not work in quite the same way, although he says it does. But at least in the method claim, where it isn't defined by function, it's defined as a method step. I don't understand at the moment what the answer is to that potential point.
So the starting point is, and I think this is the point that your Lordship was looking for, is in the supplemental bundle, tab 18,
Okay.
page 319.
Tab 80.
Tab 80.
Electronically. Oh dear. Right. Hang on.
That was a later edition, and I'm sorry for...
No, that's fine. Form of order judgment. No, extracts from opening skeleton.
Yeah, so this is my learned friend's opening skeleton at trial. This is an extract from that document. You don't have the entire document. Page 319 of the bundle is the start of the section on the claim. He says the principal claim which the court will need to consider is claim 1. Just pausing there, the reason why it's the principal claim is because some of the other claims were brought in as part of the construction arguments. And you, Lordship, may have seen in the judgment that the judge says, well, this claim helps me understand, claim 2 and 3 helps me understand claim 1. But in terms of validity, no other claims are said to be independently valid. And that was never, that was never resiled from. It was never said, well, hang on a second, we want to rely on claim 5 as being independently valid. So that's an important part of the context. And really, he needs permission to resile from that at this stage. In terms of the answer to the point, if he's allowed to run it, if your Lordship has page 109 of the core bundle.
Sorry, 109 of the core bundle.
Sorry, 108 of the core bundle. This is the judgment.
I've got it.
Okay. So and the heading is at the bottom of the page.
Yeah.
And I'm just reminding your Lordship from paragraph 315, the judge is entirely adopting Interdigital's reading of the prior art and Interdigital's understanding of how the prior art works. Okay. And then the figure at the top of the page, what you have is Interdigital's description of the prior art. So that text is the text of Townend 1, paragraph 305A.
Yes. So that stops at the end of the words. It's not the diagram.
Correct. The text, the first four lines of text are then, and then the diagram is an illustration of 305A in a particular situation, and you can see uses the grants as a multiplexing limit. Well, that's steps 1 and 2. Then selects the smallest ETFC. That's step 3, and then adds any necessary padding. That's step 4. Okay. Now. In this situation, in the prior art and indeed in the claim, there is a prior step where the UE has to work out which ETFCs are supported, and that's on a completely different. That's a completely different thing. That's based on the amount of available power they've got that they're not using for other things. And that step is in the claim. At 1E. Sorry, I'm looking at, my Lord.
1E?
If paragraph 73, page 73 of the bundle, the judge has set out the claim in a nice, convenient way.
Okay, and what was the feature you're talking about?
So 1E is means for determining the supported ETFCs
yes.
based on the remaining transmit power.
Yep.
Okay. So this diagram, all of the debate, paragraph 3, as the judge records at the end of 316. So his text from 305A contemplates that the ETFC restriction step has already taken place. That's determining the supported ETFCs. In the illustration, therefore, all the ETFCs are supported. Okay, he's correct about that. And in some cross-examination, he doesn't quote. We made sure that everybody understood that. So ETFC 5 is supported. Okay.
Okay.
We've already the UE has already worked out. I've got enough power to send ETFC 5.
Okay. Does that mean does that mean it's actually ETFCs 1, 2, 3, 4, and 5?
Correct. Yeah, all the illustrated ETFCs are supported. Yes.
Okay.
But your lordship may well have guessed why I'm stressing that ETFC5 is supported.
Right.
Okay. Well, I'll tell you, it's because then what happens? Well, then what happens is the amount of complex data is limited to ETFC4. If it wasn't for this bit of the prior art that we're illustrating, the UE would send data in ETFC up to ETFC5.
Right.
So what we are seeing here is a UE that has determined I've got enough power to send ETFC5, so I could theoretically fill up ETFC5 with data. However, what we're seeing here is the amount of data being limited to ETFC4.
Why is it being limited? My understanding of the way Mr. Speck was explaining what's happening here is that the UE identifies, let's say at step 1E, that it could use any of ETFC's. I could use ETFC5, which means it could use any of them up to 5.
Indeed.
So it knows that they're all on the table as possible. But then when it multiplexes the data, it ends up at a situation in which the amount of data required in that multiplex is a bit less than ETFC4.
Sure. But if
So it hasn't used the ETFC as a limit on the amount of data it's multiplexing.
not in that
That's the point
sense.
that's being
Yeah,
put
that's the sense you made. And the point I'm making, we'll see it from the cross-examination, which the judge quotes, is that if it wasn't for this process that we see illustrated, you could add more data,
Right.
because and send more data using ETFC5.
Yes.
The UE could, and therefore this process is limiting the amount of data.
Why? If you've already decided how much data you're sending
Yeah, but that is,
at step 2 of your diagram, why is it necessarily so that you are limiting the amount of data?
Yeah.
You're sending?
So what the judge. So if we look at the judge. So the cross-examination. If you look at the second question beginning. So in this case.
So in this case.
Philitral, that's the priority, as you understand it, would produce a MAC PDU as shown here at stage 4.
Right.
Yes.
Okay.
So in this scenario, the UE would limit the amount of MAC flow data and associated MAC header to be within the largest ETFC size that is smaller than the sum of the grants. In this particular case, yes. So the answer to that question is yes. And the judge records this at 318, and 318 is his finding of fact. Mr. Tannen accepted, and implicitly the judge accepts, that within certain particular PDC sizes and particular grants, Philitral had means which produced the result required by integer 1f. That is to say, the amount of data is limited, because without those means, it would send more data, because the rules allow you to send up, the other rules allow you to send as much data as you can fit in ETFC5. These particular rules limit that to ETFC4.
Unless I misunderstood what Mr. Speck was saying, he was saying that it's not as simple as that, because in the context of what's happening, I mean, you're quite obviously right and entitled to point to the cross-examination, Mr. Davis. I understand that. You say you put this to the expert and he agreed that this was limiting. What Mr. Speck is saying is that this isn't actually limiting.
Well, it is,
as I understand the point, or at least what's penetrated with me, what is a truism, or is at least not truism, what is true, I think, whether Mr. Speck accepts it or not, but what seems to be true is that this is a process which produces a multiplexed set of data, which is indeed smaller than the relevant ETFC, which is itself smaller than the whatever thing has to be smaller.
Sum of the grants.
The sum of the grants, yes. That's true, but that's not enough, he says, for it to be a case of limiting the multiplex data.
So in the case of claim 1, what your lordship put it as well better than I could, that means for, and then some words, means for achieving the result. And there's no question that in this scenario, the result has been achieved. The amount of data has been limited to that and hasn't.
Well, why has it been limited? I mean, apologies for me now starting to use analogies, but if I go into a shop and buy 4 sweeties and put them in a bag, and the bag happens to be big enough to have more sweeties in it, if I've chosen 4 before I just select the bag hasn't limited the number of sweeties I bought, even if it does actually mean I couldn't buy more sweeties.
Yeah. So the bag has limited it because in this example, you've got enough money for 5 sweeties.
Right.
And it's the it's the process of only using your bag. It's this process which is determined that you won't spend your £5 pence, excuse me, on penny sweets, but only on 4 pence. And that's why I drew your attention to integer 1e and the fact that that occurs. There's no dispute that that occurs in the prior art. That you first of all work out how much money you've got, which in this case is
sure,
power.
I understand.
But then, and that itself is a limit. So by saying when you integer 1e, which is in the prior art, is a limiting stage because that is saying, right, you cannot. Let's take this example. You cannot send data exceeding ETFC5. That's just not going to happen. So that's a limit.
Yep.
Okay. Now, if you stopped there and just filled up ETFC5, then you would fill up ETFC5 and you would send more data than is shown in this diagram. So it's this stage of the process which limits the amount of data to what is shown here.
Unless I misunderstood it, Mr.
Yes,
unless I misunderstood what Mr. Speck is saying, that's what you just said isn't a complete description of what's going on here. What I've understood this to be saying is that in the example, you determine the supported ETFCs, and that, let's say, is ETFC5, and therefore all the ones below it. There's then another step, which is when you multiplex the data, and you multiplex the data in line 2 of the diagram, and that produces a result, an endpoint, which is the length of that rectangle.
Indeed.
And that rectangle length is, in this example, and this is obviously, the evidence was a realistic example, at least in some circumstances, the length of that rectangle is shorter than ETFC4 as well as ETFC5.
Indeed.
And even though ETFC4 is itself lower than the grants, you select ETFC4 and then you send it.
Indeed.
And the point that's put against you is that although in some theoretical sense, by having selected ETFC4, that means if you'd wanted to send more data, you now can't, it isn't really the same as saying that you've limited the multiplex data by the size of the ETFC. Well, that's what's being said against you. I haven't understood why that's not at least arguable.
It's not arguable because the witness said, as a matter of fact, that you are in fact limiting. I mean, it wasn't an accident that the third question on page 109 of the bundle uses the word limit, and the judge said yes, and the witness said yes, and the judge then makes his finding of fact.
Yes, but what did he mean when he said, what was he agreeing to? I mean, I understand. Don't worry, I get it completely. You say, look, you asked the expert and he gave you the answer, but at the moment I'm not understanding why. As a matter of construction of the word limit, bluntly, that was the right answer on the true construction of the word limit that the claim has.
It's because in this scenario that we're looking at, the UE has lots of data to send. I mean, blocks and blocks and blocks and blocks of data to send. And it also has enough power to send plenty of data, to send, let's say, 4 MACD flow blocks. You see in the diagram, there are 3 blocks called MACD flow data. And you can see by eyeballing the picture that it's got enough power to send 4. Because ETFC.
Yes, I understand.
So it's got 100 of these blocks that it wants to send. It's got enough power to send 4. And it would send 4, but for these additional rules which are in the prior art. In other words, if you crossed out the words from the prior art that are being illustrated here, cross those words out, then you would send, in this case, you would send 4 of these blocks.
That's the bit I don't understand, because if I've got something wrong, then tell me, Mr. Abrams. But the bit that I've latched onto, which you're not helping me understand why it's not right, is that there is a step in the prior art process, which is step 2, which produces a result. I'm going to say it's a number. It's the length of that rectangle at stage 2. Now, I understand that in some sort of godlike way you can look down and say, well, the UE can send has got zillions of. I get that. It's got zillions of blocks to send, and we're talking about things, these TTIs are tiny, they're milliseconds, or maybe, I don't know if they're, yes, I think they're a few milliseconds, aren't they? And they're, you know, they're obviously therefore a lot of them, and there's lots and lots of data. But unless I've misunderstood this, step 2 is a real step. A point is made, the multiplexing data is put together in this way, the data is multiplexed in this way, and it produces a size. And that size is lower than ETFC4. Now, although in theory, obviously, if it had put together more data, it would have been able to send more blocks, and it could have added another block and gone up to ETFC5. But there's a reality, as I understand it, in which it did do that at line 2. In which case, I don't really see why, if that's right, why is it limited by the size of the ETFC4?
So if we go to the, you can see the way the prior art is written, I think makes that clear. Okay,
Makes
so
what clear?
makes the fact that I'm right and
Okay.
clear.
Good-o.
So that's the supplemental bundle, page 29.
Just a minute. Supplemental bundle, page 29. Right. So this is the standard, or this is the filiatro?
This is the filiatro prior art. The filiatro is a draft of the...
Yeah, I understand it. As I understand it, this is a markup. So
Yes.
there's a draft of one of these standards, and then Mr. or Monsieur probably filiatro marked it up.
Yes.
Yeah, that's why it's got that name.
Yeah. So this is, I think I'm right in saying he took version 6.2 and then marked it up.
Right.
But anyway, this is his draft.
Yeah.
At page 29
So we're on page 29 of the bundle.
of the bundle.
Right,
Yeah. Which is in fact page 29 of the document, and I'm at the top.
Right.
And we've talked about a process called ETFC restriction, which is the process of determining which ETFCs you've got enough power to send. Yeah, integer 1e. And no dispute that filiatro discloses integer 1e. Okay.
Right.
And in the illustration, we're assuming it's restricted to 5 or lower. Okay. And then the second paragraph says, among the supported ETFCs, well, I'll read the whole one and then break down. Among the supported ETFCs, the UE selects the smallest ETFC that maximises the transmission of data according to the non-scheduled grants and the serving grant.
Right.
Okay. So among the supported ETFCs, so in our example, that's from 1 to 5. The UE selects the smallest ETFC that maximises the transmission of data. Okay. So sending as much data as possible, and then according to the non-scheduled grants and the serving grant. Okay. So if it wasn't for the grants, the grant rules, if you created a UE that didn't implement the grant rules, this would say among the supported ETFCs, the UE selects the smallest ETFC that maximises the transmission of data, and that would be ETFC5.
Okay.
And it's because of the grant rules that you in fact limit the amount of data to ETFC4.
Yeah, and that's because the next, if you add the 4th data block at line 2 of the diagram, it would take you above the grant limit.
Correct. Correct.
So that's where those 3 blocks come from, because the 4th block would crash through the grant limit, and that's why you're stopping at 3.
Correct, but it would still be within ETFC5.
Yes.
So that's the limit. You can see I'm limiting you. If it wasn't for these rules, you could send 4 blocks plus the header, but these rules limit you. And whether it's so they've got means for limiting, and they do the method that is used in that TTI does limit the amount of data to 4 blocks in that TTI.
4 what you mean?
3 blocks. Excuse me.
Yeah, right. 4 blocks if you include the header. 3 blocks if you don't.
Yeah, let's not include the header. So 3 blocks. Apologies. So the application of these rules that we're arguing about limits you from 4 down to 3, and I showed you the prior art because it's very clear that if it wasn't for these rules, the grant rules, you would be using the smallest ETFC that maximises the transmission of data, which is ETFC5. So that's why, and we do say not just that that's what their experts said, but you've got a finding of fact from the judge who was steeped in this and understood in a lot of detail about the stages, the first stage of ETFC restriction of choosing your supported data, and understood in a lot of detail about how the amount of data you have limits what you can send, which is why I gave you the example of you've got 100, the UE has got 100 blocks to send. And he made a finding of fact at 318 of his judgment. Sorry, I'm jumping back to the full bundle.
Yeah.
That it does do that, it does limit. And so whether you say, therefore it must have means for limiting, that follows as night follows day, and therefore that the method it uses in that TTI at least does limit to the next smaller ETFC.
Right. What's actually limit? I mean, another way one might say this is what's actually limiting the multiplexed data is the grant, not the ETFC. And it's true that the ETFC is larger than the data, but the thing that's acted as the limit is the grant.
Well, in fact, that's true in integer 1F as well. I mean, if you look, it's the interaction, it's the relationship between the grants and the various ETFCs in both integer 1F and in the prior art. So the wording used in integer 1F and the equivalent integer in claim 5 is the largest ETFC smaller than the sum of the grants. I'm paraphrasing, but that's an accepted paraphrase. So in both cases, what's doing the limiting is the relationship between the grants and the available ETFC sizes.
I mean, the prior art is limiting the medium. I'm just looking at the words of Claim 5. Limiting medium access control for dedicated channel MACD flow data multiplexed into a medium access control for enhanced uplink MACD protocol data unit PDU to a size smaller than the size of the MACD flow data allowed by the grants.
So I'm a bit slow going.
Well, I mean, I'm maybe just repeating the point I've made to you already. The point you're making is that there is a limitation on the multiplex data. The point they're making is that limitation comes from the grants. Then you say yes, but the effect of it is that it does also mean that the limited size of data is smaller than the relevant ETFC size.
Yeah, you are doing what it says in Claim 5. You are limiting it to that.
Right.
And that was my question to the witness, and he accepted. In that situation, the UE limits it. And he accepted it, and then the judge accepted it as a finding, adopted that as a finding of fact.
See, that's the bit. I mean, I understand why it's accurate to say that the amount of MACD flow data is limited. I'm just not sure at the moment that I can see that it's necessarily so, that it's limited by the criterion that the claim requires you to be limited by. Well, so the witness's evidence is perfectly sensible because it is limited, but what limited it was the grant.
Sure, but it's not. It's the claim. I mean, I'm looking at Claim 5, but it's the same as it's the same in Claim 1. If we look at Claim 5, so I'm looking at column 15 of the patent. If your lordship's with me. At line 20. One second. At line 17 it says limiting, and then at line 20 limiting to. So it's not limiting by. It's not using that as a limit, which is what my learned friend would like it to be. It's limiting it to that. And it's exactly the same in Claim 1. Means for limiting to that. So the claim calls for you to limit it to that limit. You know, don't buy more than. No, the analogy breaks down. But it's limiting it to that, and not by that. And
so you spend more time trying to invent in advance spontaneous analogies.
I totally agree. I totally agree, and it's such a difficult thing to resist doing, especially when one's on one's feet. but you're limiting it. You're limiting it to that, and your lordship put the point that the patent system is not a branch of the social services, and you could have claimed it more broadly. And where this is really going, and perhaps this would sort of help your lordship, where this is really going is that the underlying invention, which the judge held was not disclosed in Filitrao, is indeed a procedure. And it's disclosed, it's illustrated in figure 6 of the patent, it's page 46 of the bundle.
Okay.
And
Figure 6, did you say?
yeah, figure 6 of the patent. What my learned friend showed you was my expert saying he understood the claim as basically being a claim to figure 6. Okay. But as your lordship has pointed out, and the judge pointed out, the claim isn't a claim to figure 6. And the point that my witness was making was figure 6 is not the procedure that's done in the standard or by my client's products. So that's why we are where we are. The patent discloses figure 6, this particular procedure. And that procedure is not required by the standard. And no doubt for that very reason, when they came to prosecute the claims in the EPO, by which stage obviously the standard will have been finalised, they had to go for something broader, and that's what they went for. So this is, if it was a branch of the social services, you'd have no sympathy for them because they had to draft a broader claim than the procedure in the patent for that, because otherwise they wouldn't finish the claim. And so when my friend talks about overarching limit, which is a phrase he used and appears a couple of times in his Skirson argument, we were the ones saying that the claim required an overarching limit, because then we wouldn't infringe, and the judge rejected that. It doesn't require an overarching limit. It just requires means for achieving this result. And in Claim 5, it just requires that sometimes you do a method which limits to, not limits by. And so that's why it is, with greatest respect, hopeless, and I'm using that in a technical sense, hopeless for my learned friend to try and incorporate bits of figure 6 into claim 1, and indeed that's why claim 5 wasn't relied on below, because it is exactly the same. It's just a method for doing. It's just a method that follows when you have the means for. Because it is means to, and it's not a method that involves any particular steps, such as shown in figure 6. It's just a method which produces that result. The means to produce a result, method of producing that result, which definitely happens in the prior art.
Okay. Thank you, Mr. Abrams. I don't need to hear from you, Mr. Speck. I've decided I'm going to give permission to appeal. I am far from convinced that this point is right, but I'm satisfied that it passes the threshold of there being a real prospect of success. And the point I'm talking about is the point of construction of Claim 1, and I would characterise the difference as being whether the claim can be understood to mean means for limiting the MACD flow multiplexed into the MACD PDUs to a size smaller than the grant, or whether it is limited to the size smaller than to the largest size of ETFC that is smaller than the size of the grant. It seems to me that there is at least a real prospect of success in showing that the construction in fact adopted by the judge's judgment is one which gives no meaning to the element of the claim which refers to the ETFC size, because the prior art attack that was successful was only one in which the multiplex data was limited by the size of the grant. As I say, it may well be that the judge was right in the end, but I'm satisfied, having listened to the argument for an hour, that there is a real prospect that it might not be, and for that reason I will give permission to appeal.
I'm grateful. Just to be clear, Your Lordship mentioned Claim 1, but I would obviously seek to argue on Claim 5 as well.
Well, I'm not going to stop you, Mr. Speck, but Mr. Abrams was entitled, as he did, to point out that you didn't say Claim 5 was independently valid of Claim 1.
I don't need to go into that. I can look at that it's a skeleton argument at the beginning before the point was raised, and there's a footnote saying there is claim 5 as well. But
All right. Well, I'm not going to get into that.
I understand.
I'm just warning you that you may find that you're met with an argument that that's not open to you.
I understand. We can have that argument if it arises.
All right. Are there any other directions that the parties need at this stage?
I think we can probably speak to each other about skeletons and listing.
That's what the rules provide for, so we'll do that.
Very good. Any other orders anybody is asking me to make?
Not today.
So the costs of today will be costs in the appeal.
Fine.
Probably worth making that order. So will we submit a
That would be very helpful, if you wouldn't mind.
Very grateful.
Thank you very much. Thank you very much.
All right.
You need a word?
Let's do that.
Yeah, somebody's going to tell us.
Yeah, I don't think there's anything else in here today. So you'll email us a draft order. What do you want us to?
Because you offered it.
I'm not. Okay. Well, if you want permission to, if you want an order saying that you've got permission to appeal, you can go for that. If you don't want to do it,
It's just I might have some people who do doing it.
We can sort it out. We'll sort it out.